Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. How you guys doing? All right, so today I am taking it back a little bit. I'm not sure if you guys remember about me speaking on the case where the Zeus bodyguard bodyguards, I should say it's plural, actually assaulted a young man while in a Foot Locker, aka Champs store in New York. He filed suit back in July. If you aren't familiar with that case, I do advise for you to go back and watch that video. But I do have an update for you guys, so let's hop right on into it. All right, so go ahead and blow this up. So, like I said before, let's go to the party. So we have Mr. Kanan Barksdale versus Foot Locker. Initially, when that complaint was filed back in July, the only persons that were listed on the initial complaint was Foot Locker, Champs, Zeus Network, Xavier Pabron, John Doe 1, John Doe 2. Those were the two individuals that was with Xavier. Once again, in that previous video, I did speak about Xavier's past with violence. So definitely watch that video so you can get a little bit more clarity and history on him. But these individuals are Zeus security, and at the time of the incident, they were wearing their Zeus t-shirts with the logo on there, so anybody can automatically say they were in the capacity of their employment during the assault. So any firm will eat that up. That's why Zeus is being included in that lawsuit. But as I was stating before, the initial complaint only included Foot Locker because that is the store that it happened in, the individuals that were involved in the lawsuit. But since then, they have added AJ Molino and Associates. And usually when you're dealing with a premises liability, we always try to go, I don't want to say always try to go, but when I draft these complaints, I'm filing the defendants, but I'm also going after the premises. So if that premises, whether it's a store, whether it's a club, they have to have some type of security, apartments, whatever the case may be. So that is why on August 30th, they did went ahead and amended the complaint to add a security company on there. And I'll pull this up so you guys can see. So while that is loading, let's see. So we have the docket here where they're initially filed. This I'll go over the answer in all of these docket entries in a second, but I want y'all to look at the amended complaint. So here, blow this up a little bit. So this is Kanan Barksdale, and pretty much everything is the same. When we get down to, what line is that? I guess I could just kind of do Control F. That would help. All right, so here is AJ Molino. All right, so they added another cause of action, which is negligent security, because these are the individuals that is supposed to be the security or providing security services for Foot Locker. And, anytime something goes down at the store, what happens? Security will come and they'll try to rectify the situation. It just depends on what their involvement was. But if security is there, you think that you are protected. All right. What AJ Molino and Associates failed to do is protect the plaintiff from the Zeus Network bodyguard. So that is why they have been included. Some of the things that that the plaintiff's attorney added is that one thing, AJ Molino was responsible for ensuring that patrons, customers, and invitees did not act in a reckless, negligent, or criminal manner. They failed to provide security. They failed to take necessary safety precautions to protect persons lawfully upon the subject premises. They failed to properly monitor the store and or security cameras and thus allowed the assault of plaintiff to occur. So also failed to properly maintain the security at the subject premises. Failed to properly manage the security at the subject premises. Failed to properly oversee. So all of these things, they negligently allowed assault on the premises. So it's all these different things that they failed to do, and that is why they are being included into this lawsuit, as the plaintiff has the right to do so. So with that being said, so all of those defendants must be served. And the first person who actually answered was Foot Locker. And usually anytime a defendant answers, it's really going to be a general denial. Okay. It's not going to be something where they're going to admit to anything. We're just going to deny all the allegations in there, and we may add some affirmative defenses to that as well. Sometimes defendants end up doing a countersuit. So here, let's see. So here, deny knowledge of information sufficient to the form of belief as to the allegations contained in paragraphs. So what they did is they looked at the petition, they see exactly, what paragraph that they're going to deny, and then they'll enter a denial. Okay. So they deny any knowledge or information to these particular paragraphs. They deny each and every allegations contained in these particular paragraphs. What else? And so here they have an answer for each of the responses. The response to paragraph 25. Let's see. Trying to get something juicy. And it's going to be the same thing. Whenever you respond to a lawsuit, just enter a general denial. That's all you have to do. So they're denying each cause of action. And this is just for Foot Locker. I do not want to pull up the complaint. So you have the first cause of action, the second cause of action, third, fourth. All right. Fifth cause of action was against Xavier and John Doe 1 and John Doe 2 for committing civil assault and battery. Let's see. The sixth cause of action was enabling criminal and civil battery against Zeus Network. The negligent hiring and supervision of retention against Zeus Network. And see, a lot of this does not apply to them because they're not Zeus, or they're not Xavier or John Doe 1, John Doe 2. So it makes sense for them to deny those allegations because they don't have enough information, or the information is insufficient to say whether or not they, those allegations are factual. And so they just went through each cause of action. If it applied to them, then they deny it. If it doesn't apply to them, they deny it. Okay. And then they went ahead and they did put in their affirmative defenses. The first one is that the answering defendants were without notice of any of the purported conditions alleged in the verified complaint. For the second affirmative defense, it says upon information and belief that whatever damages the plaintiff may have sustained at the time and place mentioned in the verified complaint were caused in wholly or in part by the culpable conduct of the plaintiff, meaning that he caused his own injuries. I'm not laughing, but that's pretty much what they're saying. They're saying that we don't have anything to do with it. Whatever happened to him was because of the conduct of the plaintiff. The amount of damages recovered, if any, shall therefore be diminished in the proportion to which said the culpable conduct attributable to plaintiff bears to the culpable conduct which caused said injuries. Third affirmative defense, in the event plaintiff recovers a verdict or judgment against the answering defendants, said verdict or judgment must be reduced pursuant to the CPLR 4545C by the amounts which have been or will, with reasonable certainty, replace or indemnify plaintiff in whole or in part for any past and future claims economic loss from any collateral source. Fourth affirmative is if in the event answering defendants are found to be liable to plaintiff, answering defendants' liability is 50% or less, therefore answering defendants' liability is subject to the provisions of the CPLR Article 16. Fifth affirmative defense, upon information and belief that the injuries and damages alleged were caused by the culpable conduct of some unidentified third persons or third person or persons over whom answering defendants exercise no control, but including but not limited to the allegations of assault and or battery. I'm sorry, y'all, I'm a little tongue-tied. The sixth affirmative defense, upon information and belief that all risk and danger of loss or danger connected with the situation alleged in a verified complaint were at the time and place mentioned obvious and apparent, were known by the plaintiff and voluntarily assumed by the plaintiff. Yeah, and you see how they put everything back on the plaintiff. The seventh affirmative action, plaintiff failed to negate, obviate, diminish, and otherwise act to lessen or reduce the injuries, damages, and disabilities alleged in the verified complaint. Eighth cause, or affirmative defense, plaintiff fails to state a cause of action for which relief can be granted. Ninth affirmative action, that the occurrence alleged herein was spontaneous and unavoidable and could not have been caused, anticipated, or foreseen by the answer defendants. 10th affirmative defense, while the answering defendants deny the plaintiff's allegations of negligence, liability, statutory liability, strict liability, injury, and damages, if proven they were the result of intervening and or interceding acts of superseding negligence, liability, statutory liability, strict liability on the part of parties over the answering defendants, neither had control nor the right to control, and for which acts or admissions this answering defendant is not legally responsible. 11th, it says any defect alleged by the plaintiff herein was so trivial and therefore not actionable. The 12th affirmative defense, the answering defendants reserve the right to claim limitations of liability provided pursuant to the General Obligations Law, Section 15108. 13th, plaintiff failed to seek prompt, adequate, and proper medical care. Ooh. So that means, and that's why I tell people when you're dealing with injury cases, especially in this matter, the first thing you should have done, one, was call the police. Get checked out by EMS, go to the emergency room. Okay? The next thing that you want to do is hire an attorney. Okay? Seek medical treatment. If you are claiming, you cannot file a lawsuit for damages or assault that, assault or any type of personal injury matter, and you do not treat. That is the biggest thing. The only way you can prove your damages is by having medical records. And you get those medical records by going to a medical provider. And you prove up your damages by showing the amount of your medical bills. It all plays a part. The fourth affirmative defense: upon information and belief, plaintiff alleged damages were caused by pre-existing medical and health conditions. So what they're saying is that if he's sitting here trying to claim any type of injuries, injuries, like if he has back problems, if he's claiming like he had a shoulder injury or a back injury, they're trying to say that he had these prior to this incident. They said information and belief, so I'm pretty sure they have done their research. Upon information and belief, whatever damages the plaintiff may have sustained at the time and place mentioned in the verified complaint, these damages were approximately caused by the acts and omissions of the plaintiff, and that the plaintiff's acts and or omissions were the sole proximate cause of any and all injuries alleged by the plaintiff. 16th affirmative defense: answering defendants did not breach any alleged duty. 17th affirmative defense: the verified complaint fails to name a necessary party or parties which allegedly caused the injuries sustained by plaintiff. Now, I could have sworn that it said that, it said exactly who was responsible, but that's neither here nor there. Eighth affirmative defense, 18th. Plaintiff provided either express, implied, or assumed consent to the activities referenced in the verified complaint. I don't think anybody give consent to get beat up. 19th affirmative defense: all conditions precedent to recovery by plaintiff have not been satisfied, thereby barring recovery to him. 20th shows that they were properly discharged under the doctrine of necessity and in defense of property. 21st shows that plaintiff claims in part or in whole are time barred under the applicable statute of limitations. 23rd, let's see, that if the plaintiff sustained injuries and damages in the manner alleged in a verified complaint herein, which is expressly denied, it will be claimed that any of the answering defendants' acts were justified under the circumstances existing at the time of the alleged incident. 23rd shows that if the plaintiff sustained injuries and damages in the manner alleged in the verified complaint, which is explicitly denied, it will be claimed that the incident complained of was caused and or provoked by the conduct of the plaintiff, and accordingly, any damages that may have been sustained by the plaintiff must be reduced or mitigated accordingly. And there have been a few cases where I have assisted where we represent the defendant, but I do more plaintiff personal injury than I do defendant. And it's crazy how on the defendant side, you have to get into that mode and be like, okay, plaintiff was responsible for their own injuries, or plaintiff had these injuries before before this incident. So it's not a matter of the lawyer trying to pin it on them. That is just kind of the way that when you draft these type of complaints, how you would answer. So it's like you putting all of the burden back on the plaintiff to prove. That's why I always say the burden of proof is always on the person who files the lawsuit. You have to be able to provide proof, tangible proof, things that we can read, that we can see, to say, okay, this did happen to me. Here are my damages. Pay me. Okay, I've told you guys time and time again, anybody can sue for whatever reason. You have to be able to provide proof. In any injury case, you have to provide proof. Now, if you was injured, don't wait 3 months later to say, oh, let me go to the doctor because now I'm trying to get paid and I know this is the only way I'm going to get paid. Because in an insurance company mind or a defendant, like especially for myself, if I'm looking at this and I say, oh, well, it doesn't show that you went to the doctor 3 months later. How do we know, one, that those injuries were sustained by this particular incident? Okay. And then two, you've already healed. But at the same time, it is just going to be hard for anybody to prove that the injuries that you sustained is related to that incident. It's very, very important that you go to the doctor that same day and you follow the treatment plan. If they tell you to follow up with such and such in 2-3 days, you need to do that. And then whoever that doctor is that you've seen, they will let you know, okay, you need to go see an orthopedic specialist, or you need to go see pain management, or you need to go to a chiropractor. All right. Um, as for 24th affirmative defense, answering defendants reserve the right to assert additional and or affirmative defenses based on the information obtained through discovery and inspection. So they can actually amend this answer and add more affirmative defenses as needed. So they are demanding judgment, dismissing the verified complaint together with the costs and disbursements and counsel fees incurred in defense of this action. So this is Foot Locker's answer. Okay, so they denied every single thing in the verified complaint filed by the plaintiff, and they added their affirmative defenses. Okay, pretty much putting everything back on the plaintiff, saying that he is responsible for that incident and his injuries that he had is pre-existing. It has nothing to do with this incident. So now the ball is back into the plaintiff's court, having to show that he did, in fact, sustain these injuries from those particular defendants back on that date. And Foot Locker failed to, utilize their security company, and the security company failed to do what they were supposed to do. I hope that makes sense. All right, so going back to the court docket, in addition, so prior to August 30th, what they did was they were not playing. They submitted a notice of deposition upon oral examination, a demand for bill of particulars. All right, so let me pull this up. So I am pretty sure at this point, they are saying we need copies of your medical records and your bills. Ah, all right, so let's see. And they have to produce these documents in the presence of a notary. So it's like we have to verify that these documents are true and correct copies. Let's see. So they're wanting to know, and this is something that we always have to do. So date, time of the incident, the exact location. Let's see. Statement of injuries. Statement of whether the plaintiff was employed. Statement if you're claiming lost earnings. Were you a student? Were you confined in the hospital? Were you confined in the bed? Let's see. How much money actually expended for hospital? the physicians, the nurses, the medicine. So pretty much those medical records and bills. If you're claiming you're injured, you need to produce those bills. And normally, see, I don't know how New York does theirs, but I know for Texas, anytime we're doing litigation and I am requesting records, medical records and bills, I have to do it by affidavit. So affidavits, we know, have to get notarized. So what happens is the medical providers or whoever the custodian is will pull all these records and say, okay, I have, 120 pages in the medical records. And they will fill out that affidavit. A notary will notarize it. Then you have a billing records affidavit. So they'll say, okay, the total amount that is due or the total charges for the services that we rendered to the injured was in the amount of $20,360. Okay. And so they would complete that, put that number down, and they'll notarize that. And those affidavits is because we know that affidavits are pretty much, especially when you get it notarized, it's like your truth. Okay. So that's why medical providers have to do it by affidavit. Like I said, I don't know how New York does it, but I do know in Texas, that's how we are able to prove up our damage. Well, not our damages, but the client's damages because those documents are notarized. Now, what will happen on the defendant side, they will look at that and say, okay, we see that you spent $20,000 on chiropractic treatment, but they'll look at what they call it. Oh my gosh, I just went blank. They'll pretty much what they'll say is, okay, this treatment is not worth $20,000. More, it's worth more like $7,000. And so they would actually, what they call it, they'll file like a counter affidavit, and then we got to go through a whole process. But anywho's, they are demanding all of these. So they're demanding medical records, medical bills. If you're saying you have a loss of earnings, they want a letter from your employer. If you saying that you was admitted to the hospital for 10 days, they need proof of that. If you saying that you was in your bed, you was bed bound for so many days, they want proof of that. What else they're saying? If complaint alleges loss or damages of any personal property, list the personal property that was damaged, the value of that, any real property. So this is just kind of basic stuff, but this is mainly for, the injury portion of it, and for Foot Locker to see, okay, how do we play a part? How are we liable in this incident? You need to prove this to us. You need to provide documentation. And that's what this is. This is what it is. So this is how the plaintiff is going to be able to prove that Foot Locker is responsible, and to prove his damages as far as whatever amount he's claiming he's suing for. All right, so that's the answer. That's the notice of deposition. So pretty much any of the documents that they demand and he provides, he has to take it to a notary so that way they can pretty much, in a sense, certify them. All right. And then last but not least, it shows that on September 30th, Zeus Network was actually served, as well as, well, I don't know if they were served, but they filed the proof of service or affidavit of service on September 30th. So the security company and Zeus Network. So let me click on it and see exactly when they were served. All right, so here it shows that on August the 8th at 12:15, they were served. Oh, and it says notice of electronic filing. So this actually went to via email. Interesting. Let's see, 20 days, 20 days, 20 days. I'm trying to see exactly when they had to respond. Yeah, it doesn't show, But I know within between the 14 to 35 day mark. So if they were served on August, their response had to it like September. September is when they had to respond. So as you can see, Zeus has not responded. And on 9/26, AJ, the security company, was served. So their response is due anytime this month. But for Zeus, they haven't responded yet. So if I was on top of this, I would I would already put in my entry for default judgment against Zeus Network. I'm just saying. But yes, so that is the update with Zeus Network and Kanan Barksdale. Once again, this is in regards to Zeus bodyguards actually assaulting Mr. Barksdale in Foot Locker in New York, and he is suing for damages. And I just hope that he has done everything that he is supposed to do in order to prove up his damages in court, because this is going to be a battle. But it's very interesting that Zeus Network has not responded to the lawsuits, which is weird. But I will definitely keep you guys up to date on that particular case. I know that when I was on break, I want to say back in August, but probably before then, y'all know I had to go on a hiatus. Mr. Barksdale did reach out to me regarding his case, so I may do an interview with him to kind of see exactly what happened. But I don't want to do too much because it's still in litigation process, and when we get to, a lot of people don't understand the litigation process, but like when you do depositions, you don't want to say too much because you don't want to, how can I say, diminish your chances of getting a settlement. Okay. So with the process right now, everybody's in the process of getting served. Once they are served, then they go through a discovery phase where they do interrogatories, requests for admissions, and requests for production. So that's where the plaintiff will have to gather all of his documents to prove that, medical records, loss of earning records, all of that good stuff, is submit that to opposing counsel. And opposing counsel will get the same stuff from the plaintiff attorney and would have to provide over to the plaintiff's attorney. Once discovery phase, as far as like the documents, the derogatories, the interrogatories, requests for production, as well as the admissions have been answered and exchanged, then they'll do depositions. Once depositions take place, then they'll move to mediation. If they can't settle in mediation, then it's going to be set for trial. So that's normally what the process is. So I do hope that Mr. Barksdale doesn't take it personally if I don't have him come on the show. It's not that I am ignoring you. It's just that I work in this particular area of law, and when it comes to personal injury, you have to be very, very careful of what you say, especially on social media. But that's neither here nor there. Hit me up in the back end if you want more information on that part. But anywho's, for my viewers, my subscribers, and my members, tell me what you think about this. Do you think that Mr. Barksdale is going to come out on top? Do you think Zeus Network is actually going to respond? That is, I see them doing all of this, but yet your legal team can't file a response. Don't forget to like, share, and subscribe. Until then, y'all be blessed, and I'm out. Bye.